all hear me? It's up to you if you want to put your cameras on while we have this meeting. Somebody has held some spaces while we're doing this. But please put yourselves on mute. You all hear me? You're not talking. It just gets rid of any feedback. It's up to you if it might occur. Put your cameras on while we have this meeting. Somebody has held some spaces while we're doing this. I'm Trudy Craggs, and I'm a reporter with Scottish Government's Planning and Environmental Field Division, DPEA. Gets rid of any feedback. It's up to you if it might occur. Put your cameras on while we have this meeting. Granton, Waterfront Phase 1 while we're doing this. I'm Trudy Craggs, and I'm has made yourself on mute. You all hear me? You're not talking. It's just DPEA. Gets rid of any feedback. It's up to you if it might occur. Put your cameras on while we have this meeting. Waterfront Phase 1 while we're doing this. I'm Trudy Craggs. Stored as part of the DPA webcast website archives and will be capable of repeated viewing. By participating today, you're consenting to being filmed. You're also consenting to the use and storage of these images and sound recordings, and if any images or information pertaining to you contained in them, for webcasting and training purposes, and for the purposes of keeping historical records and making those records available to the public. If you want further details on our privacy policy, that can be found on our DPA website. I can pass a link to anyone who does want to look at that. So first of all, thanks to my colleagues David and Rebecca for arranging today's meeting. They'll both be in the background and they'll step in if there are any technical issues, but hopefully there won't be. But if anyone loses contact or can't hear or see, please flag or put something in the chat and we can get that sorted out. So as I said, I'm a reporter and I've been appointed by the Scottish Ministers to consider the order and the objections to it and to hold a public inquiry if necessary, and to submit a report to Scottish Ministers making findings in fact and recommending whether or not the order should be made. So before we go any further, I'd like people just to introduce themselves so I know who everyone is, because there's some names that I'm not so familiar with. So if I asked the lead participant for the council to introduce yourself and anyone attending on behalf of the council today, and at this point it might be helpful to put cameras on so people can see who's talking and what people look like, because you just get a sea of pictures on your cameras, I'm sure. So can the council kick off first with lead participant and those appearing on your behalf?
Yes, thanks very much, reporter. So I'm Sat Patel. I'm the council's programme director for Granton Waterfront regeneration. Obviously the regeneration project that we're seeking to secure the land assembly that's required for taking forward delivery. With me today is Graham McGartland, who is our head of estates and leading on the negotiations with the landowners. Along with Graham is Andrew MacDonald and Rosalind Kelly, and they're both from our legal services team and our legal representation on this.
Okay, thank you for that. So if I turn to those third parties who are attending today, the objectors who are attending. Now, my understanding is that Mr. Jennings, you're appearing on behalf of Lidl, and Scott Mill is also with you today. Is that correct?
That is correct. Daniel Wheelwright also is here on behalf of Lidl from Rapley's. Scott Mill
Thank you.
Will be our lead. Scott Mill will be our lead today.
Oh, perfect. Thanks for confirming that. Okay. Next one I've got in my list is, hopefully I'm saying these names right, Leo Ferreira.
That's
you're
correct.
Appearing
Leonardo
Ferreira, and you're appearing as Leo's Garage.
Correct.
And you've got an interest in 298-304 West Granton Road as the tenant. Is that correct?
And also 306 West Granton Road. So there are two properties. Yeah, there are two properties.
Okay. Now, is your advisor, Ms. Boyle, also attending today, or are you just attending?
Are you talking to me, Leonardo?
Sorry, she's here for your landlord. Do you know she's attending today or not? Maybe you don't know.
My landlord is not with me today. No.
Okay, that's fine. They may join the call at some point.
Okay.
Okay, so thank you for coming along today. The next people I have on my list is Mr. Stringer, and you're appearing on behalf of Mr. and Mrs. Delicato in relation to plots 3 and 5. Is that correct?
That's correct, yeah.
And do you have anyone else with you today?
My colleague Neil Wilson's just sitting in with me.
Oh no, that's fine. Just whether there's anyone else on screen that I should be aware of.
No. He's camera shy.
Okay, next people I've got are I think it's hopefully again I spelled say the name right. Mr. Wiertrowski of KJJ Foods Limited.
Hello, my name is Anna and I'm accountant for KJJ Foods, and Jarosław is just sitting next to me as well.
Hello.
Hello, thank you for both joining. And you are tenant of what I know is plot 3 of the CPO.
So 316 was Granton Road. So basically
Yeah.
some Mr. Delicato property.
Yeah, so it's 316 and 316B, isn't it?
Yes, that's correct.
Okay. Okay, now I'm also just looking at the list of people to make sure I haven't missed anyone. Mr. Series, can you just outline who you're here for?
Yeah, sure. So I'm Meryl Boyd's colleague. Meryl's on leave today, so she's asked me to stand in representing D&L in Granton Limited.
Great, thank you for that. And I think everyone else has introduced themselves. Have I missed anyone? Right, no one's shouting, so I'm assuming I have got everyone. So that is great. That is everyone who I expected to be represented or attending today here, which is great. So thank you for that. So I sent out the agenda, or the case officer Jane did last week, week before. So we've covered item 1, which is the welcome and introductions, and item 2 was the purpose of this meeting. And I know a lot of you probably have never been involved in this kind of process before. So if you do have any questions, either wave your hand if you're on camera or try and butt in if you want to ask a question, and I'll do my best to deal with that as we go along rather than saving up to the end, just so you all understand what we're doing as we go through the process. So the purpose of the meeting is to discuss the procedural arrangements for any inquiry that we may have as a result of the objections to the order. This meeting in itself does not form part of the inquiry process. There will be no discussion on the merits or otherwise of the order or your cases. So I'm not here to discuss what your objection is or get into discussion about compensation or heads of terms or any agreement you might be discussing with the council. Really, I'm just looking at this stage at the procedural aspects and to understand what falls within my remit and the scope of any inquiry, and what would flow afterwards if the order is confirmed and then implemented, and then compensation entitlement kicks in, because they're kind of 2 separate processes, albeit that they are linked. I will be keeping a note of the discussion, and a note of the meeting will be circulated to all those who attended today as soon as possible after this meeting. So hopefully that sets out for everyone the purpose of today's meeting. I say it's very procedural, and it's not discussing the merits or otherwise of the objections or the order. So leading on from that, item 3 is my remit and the scope of the inquiry. So the order is proposed to be confirmed under the Town and Country Planning Scotland Act 1997, and the process for making and confirming compulsory purchase orders is set out in the Acquisition of Land Authorisation Procedure Scotland Act 1947. There are 2 of the documents which might be of interest. They are the Compulsory Purchase by Public Authorities Inquiries Procedure Scotland Rules 1998, which apply to compulsory purchase by local authorities, and again they set out some procedural rules. And there's also a circular, which is 6 of 2011, which explains the rules and the process in plain English. Now, if we are proceeding to an inquiry, I will put links of both these in the note of this meeting. They're quite useful documents to have a look at if you are going through the process. particularly the circular, which is plain English and takes you through the various stages. Even after the inquiry process, I think goes on to compensation and things like that. So it's quite a useful document just to have a look at if you're involved in this type of process. So my remit and the scope of the inquiry is prescribed by the legislation I've just referred to. And as set out in the 1997 Act, any objection that relates exclusively to compensation matters can be disregarded, as those are matters which would be considered and determined by the Lands Tribunal, not me, if the order is confirmed and agreement cannot be reached by the parties. So that's just to clarify that the scope of the inquiry is really looking at more details of issue about the order, why the order is being made, not compensation. And we'll come on to that later when we're discussing which of the objections fall within this remit and which would really be matters later on in the process if the order is confirmed and then implemented by the council. Does anyone have any queries so far? No, okay, so everyone's happy to go on to the next one. So at this stage, what I would find useful would be an update on any negotiations between the council and the objectors. My understanding is that there are 6 objections to the order. That's what I have before me. And as far as I'm aware, none of the objectors have been withdrawn so far. But the council can confirm that in a minute for me. So I would just like an update on the status of objections. If you think something's going to be withdrawn, a time frame. What I'll do is I'll ask the council to go first. And if you deal with each objector individually, and once you've spoken about one objector, if they are here or represented today, I'll ask them to comment, and that'll give me a good picture of where each objector is. So would the council like to start with this one? I think you, Mr. Patel, will take this for you.
I'm going to refer to the specialist. Thanks, reporter. So I'll pass over to Graham and to Ros. I think it's a bit of a double act. I think, Graham, if you could maybe update in terms of the status of the negotiations that are going on, and Ros or Andrew, if you could update on the kind of status of where the objections are at the moment, I think that would be very helpful. Thank you.
Okay, and if we can do it per plot, and then I can get the other objector to come in and comment too, that'd be helpful. Thank you.
Okay, thank you. So plot 1, we have had discussions with Lidl's and also National Galleries, and the position at the moment is that those parties are negotiating direct because it's a servitude over that part of land that is required rather than acquisition by the council. So as far as I'm aware, those discussions are ongoing at the moment.
Mr. Mill, do you want to comment that on behalf of Lidl?
I think that's an accurate representation of where things are at. Papers are currently with National Galleries or with City of Edinburgh Council drafting a deed of servitude for consideration by Mr. Jennings, who's the property lawyer.
Thank you. That is helpful. So Jennings, do you want to add anything, or you just that summarise the position from your perspective? Your involvement would be later on.
No, that is correct. What Scott's analysis is quite right, and we hope to progress with that deed of servitude.
Okay, thank you. So plot 2.
Okay, so plot 2 is what the council consider maybe one of the more complex ones, of which there's probably 3 come under that description. And in those ones, and this one in particular, we have asked the district valuer to act on our behalf to negotiate with the relevant parties. They have been instructed, and they will be given and have got the contact details to make direct contact shortly with the relevant parties, but they have not made any approach yet.
Okay, so Mr. Ferreira, you probably have not much to add to that if they haven't made contact with you yet. Is there anything else you do want to add, though? You're on mute if you are speaking. I can't actually see you.
Yeah, directed at myself, sorry.
I was going to Mr. Ferreira first.
Hello. Hi.
I was going to say, you might not have much to add if the District 5 hasn't actually contacted anyone yet, but is there anything you do want to add in relation to your discussions with the council so far?
Well, perhaps another meeting, another more deep explanation about it. To be honest, I see most of you here are knowledgeable about it. I'm quite unaware of most things happening there. I just need to, I don't know, I can take an advice as well from yourselves. Maybe where should I speak to? Well, who should I seek for? And I've been, a tenant for quite some time there, so I just don't know exactly where to go. It's a new thing for me.
Okay, I appreciate that. It's not many people get involved in compulsory purchase orders, and it can be a bit intimidating. I'll come back to your points in a minute. If I come to Mr. Series, can you put yourself on mute? Thank you. Mr. Series, can you comment on behalf of the Vernos, please?
I think that's what, as I said, I've just stepped in today, but I think that's what I understood. We're waiting for contact from the DV. Could I just ask, is there any timescale for that I could feed back to my client?
We have asked the DV to make contact as soon as possible, so we'll try and get them to be in contact with you if we can, initially no later than this time next week.
Thank you.
Sorry, Graham, just to say that the DV had responded today to say that they were actually going on annual leave. So I don't know if it will be next week. Certainly they're back, I think, next week, to the tail end of next week. So we will certainly, Mr. Series, we will get them to get in contact as soon as they're back from leave.
Okay, thank you.
I'll say a bit more about process just in a minute, but can we come to plot 3, please?
Plot 3 is as per plot 2.
Mr. Stringer, do you want to add anything to that?
Well, hopefully we're a bit more advanced than plot 2, because I mean I've had correspondence with Andrew McDonald here this morning. So I mean there's been a meeting arranged provisionally for the 18th of April. Hopefully that's going to involve the DV, Andrew. I don't know if Graham's going to be there. I'll be myself and our client surveyor. So it's just to discuss, take forward a proposal which we're calling a kind of the November agreement. Okay.
Yeah.
So it's there, but just on that, if it's not appropriate, shoot me down. I mean, 2 things of this, and just of this compulsory purchase. My understanding is that part of where my client's property is, the people who are going to develop that site are Crudens. Now, they've not put a planning application in for this yet. So, is this all a bit premature, or how quickly is it going in? And I think just as part of these other discussions, I think everybody's discussions, it is forming a timeline of what's happening here, because that's going to be crucial, particularly if not just the owners, if there are tenants there. I mean, can we actually work to realistic timescales so we can actually, preserve people's livelihoods and work? So, but that is going to be predicated on the actual development timescales. And that is only going to be if there's no planning application as yet, although I understand it might be imminent, but I mean, so I think just a more understanding of that, and with the CPO is going to be better. So whether that's appropriate here, but that's the concerns here of just working with the CPO and what's the timescales going to be when we're trying to work out a commercial deal. It's got to be with a realistic time frame.
Okay, I know there are concerns about the timeline. Take that one first. Obviously, at this point, the CPO has been made by the council. It is then passed to Scottish ministers. It comes to me as the reporter. I don't make the decision on whether it should be confirmed or not. I make a report with recommendations to the Scottish ministers, and that then is up to Scottish ministers to determine. So to give you an idea of a timeline from my perspective, I have a target date as reporter to do the inquiry, hear evidence that I need to hear, write up the report and get that to ministers. So my target date, which is on our website, so it's very public for everyone to see, is the 3rd of October this year. So I'm not saying it would take that long, but I'm just saying let's give it a guide. So the 3rd of October this year, it would then go to Scottish ministers. Now, I have no control as to how long Scottish ministers may take to consider the report and decide if they want to confirm the order or not. It can be as long as it needs ministers to take, to be honest. I've got no control of that, and nor does anyone else. We do lots of reports to ministers on wind farm cases, other CPOs, and it's varying amounts of time it takes for them to come out with a decision. So I can't control that at all. I imagine that maybe best the tail end of this year, maybe Q1 next year. Maybe you're looking at maybe slightly later. I don't know. Following on from that, my understanding is the council would then have to implement the CPO. So just because the council has a CPO, you need to go through a process, as far as I understand it, to get possession of the land or to acquire the land. And that in itself takes time. There'll be various notification processes that need to be followed through. And depending on the council does it, which process to use, notice to treat or general investment declaration, that also takes time. And that might take 3 to 6 months, depending on how long it takes council to actually do that process. And that's when the entitlement, as I understand it, kicks in for compensation. So I guess taking all that into account, and I'm not the council and I'm not in control of any of this process, part of this front end bit in writing my report, that's my bit that I am in control of. You're maybe looking at, I don't know, early spring, middle next year, when the council would be implementing the order and acquiring land. So I don't know if that helps everyone. I mean, as I say, I'm not in control. I'm just trying to give a little bit of guidance from my understanding of the process, is perhaps when the council would be in a position to actually possess and take acquisition of the land and for compensation to kick in. So think about that as your timeline. The council may want to comment on that in a minute. In relation to the other point about the planning application, there are a couple of matters that I will be seeking further written submissions from the council on. And that will be one of those matters to get that clarified. And that will be set out in the note of this meeting. So I will be picking that point up, because I had noted that I think in the statement of reasons, it was to be submitted, I think, winter 2023. So I was going to ask for an update and a timeline, but it's helpful that it's been clarified today. It's not been submitted, but I will be asking further information as a written submission. So that gives the council a head up on that. So Mr. Patel, do you have any comments to make on the actual timeline I've outlined? I'm just trying to be helpful to people who are not involved in the process. I'm not trying to tie you down, because it's your process, and as I say, I'm only involved in the first bit, and that's the only bit that I can actually control.
Thanks, reporter. So on the first point, I think we have certainly, and that's gone out in the objection letters, that's the timescales that we are working to. So we've previously said to the objectors that the aim would be to try and secure the land holdings by spring, summer 2025. And that's in line with our timescales for progressing the project. So we're aiming to have project approved by our elected members in spring 2025, which would then allow us to do site-wide enabling and infrastructure. So that's why we need the land holdings at the beginning to allow us to carry out that enabling and infrastructure work. So it's certainly in line with our timescales, and that's why we've been progressing the CPO order process in that way. What I would say, and what we've always said, is that we're not solely relying, of course, on the CPO process. We're trying to negotiate in the first instance. So the CPO is simply a backstop for us. So we have been clear from the beginning that we want to negotiate and do it through voluntary negotiation in the first instance. On the second point, I can confirm that we haven't put a planning application in yet. You're absolutely right. We did say in the statement of reasons that we were targeting winter 2023. Unfortunately, the design development's just taken us slightly longer. We're now targeting the end of May, early June for planning submission, so it is very imminent.
Okay, thank you for that. And I agree that if you can negotiate and objections are withdrawn, that is welcomed. And that can happen at any stage during this process. So people shouldn't feel that because we're in this process, nothing more can happen. Objections can be withdrawn at any time, and we amend our process accordingly to reflect that. Thank you for confirming on the planning application. I probably will also write, I think I've got another couple of points I'd like some clarification on, but again, I'll set that out in the note of this meeting. Mr. Stringer, does that help at this point in time? And anyone else may want to add at this point? Mr. Stringer, I'll come to you first.
No, it's good. And I mean, I think we do want to do by negotiation. These timescales, I think, should actually allow us that, okay? But I do think we just have to consider, and again, in advance of this meeting on the 18th of April, I mean, there's a CPO, but separately to that is the planning consent and the people building the grounds, which are going to be part of maybe a commercial deal. So we have to look at that. I mean, I know we've got the spring date, but let's work in reality. People have to, houses which have got planning consent or buildings which have got consent and they're going to be built, and that might push out some of the period of the commercial agreement. I just want that to be considered as part of the negotiations, and I think that should be so. Well, that's something maybe that I can have on the meeting on the 18th of April. But other than that, it all sounds positive. Thank you.
Does anyone else have any questions or queries on the process that I've just kind of outlined? I know it's probably a lot to take in, but if there are any queries, then please just let me know. I'll try and help at this point. Okay. We have covered an update in relation to all plots where there's an object here. So that's plot 1, 2, 3, and 5. Is there any update in relation to plot 4 and 6 where there's no objection?
Yeah, plot 4 and 6 is what we're thinking should be more straightforward potentially. So we have made an offer to the representative for the executors of the owners of those 2 small areas of land. We have not yet heard back, but an offer has been made to purchase. Okay,
thank you. And I say if there's further progress and objections are withdrawn, then just let the case officer know. That's always welcome from our perspective, and it's always good if things can be done by agreement. Okay, so now we've established where we are with objections. It sounds like some of them are kind of an early stage. The DV needs to get involved and start negotiations, but at least there's a process to be kicked off and be started. We need to discuss whether the objections that are before me fall within the remit of the inquiry. So as I did explain, if objections relate exclusively to compensation matters, they can be disregarded as compensation matters are considered by a different forum, and that is the Lands Tribunal. And they will consider it if the compulsory purchase order is confirmed, and if it's implemented, and if the parties can't reach agreement. So it's like a tail end process. They come at that point, and they would be the ones that would look at the compensation calculations and decide if it's fair, reasonable, in accordance with legislation on how compensation is calculated. Now, I can't comment on that at all. I'm no expert in compensation, and it's not a process I'm involved in, but that's how it would work. It's a tail end part of the process once we've gone through this part, and it would kind of kick in if parties can't reach agreement. So having looked at the objections and considered them, I note that the one on behalf of the Delicatos does raise some procedural matters as regards descriptions in the compulsory purchase order, which I'd need to narrate in any report that I do. But the rest of the issues seem to relate to compensation. And as for the others, the only other one that I think doesn't relate to purely compensation matters would be the objection from Lidl. So I think I'd be saying that the objection is for plot 2. That's the Verno's objection and Mr. Frere's objection for Leo's Garage, and KJJ Foods, and predominantly the one on behalf of the Delicatos, all relate to compensation matters. Now, I'd like to know if objectors agree with that and the council, to know, because that then kind of helps me understand how we go forward with this process. So can I get the council's view on my understanding of the objections?
Can I jump in here?
Yeah, thanks.
I would
thanks,
agree
Liz.
with that, yes. As regards plot 1, most of the objections from Lidl don't relate to compensation. Plot 2, I would say agree with you that the objections are solely compensation related. And plot 3 and 5, as regards Mark and Susan Delicato, some of those are compensation related, but a couple I think should still be taken into account. So yeah, I would agree with that.
Okay, thank you for that. So can I now turn to each objector and get your views on where you think your objection lies, whether you think it's purely compensation or there's some other residual matters that I would need to deal with. So first of all, for Lidl, Mr. Milne.
Okay, yeah, I think that the objections already lodged on behalf of Lidl sets out quite fully what their objections are. The main issues seem to be the scale of the land which it's proposed to be acquired, and whether or not the same purpose can be achieved by servitude rather than by acquisition. It also has to do with the protection of the subtenant, or rather the tenant, of part of the Lidl site. They're here both as proprietors and operators of the supermarket, and also as landlords of a unit occupied by Baines, and they enjoy access at the moment by pedestrian means from the principal highway, and that has to be protected because the public are less likely to walk the extra 100 metres along the main road, then back 100 metres to get access to the Baines shop. There's also issues in connection with service media, which it's thought probably cross the road, not the road, sorry, cross the area of ground in question, and the protecting the interests of both Lidl and Baines in what's already a challenging consumer market. So all of these issues to me to go to the merits of the CPO rather than just to compensation. And it may well be that the discussions which are already underway will result in some form of agreement. Certainly that is Lidl principal objective. I don't think Baines are represented here today.
I think there's a representative of Baines watching the live feed today.
I see. Okay, so they may well be able to speak for themselves. I make it clear I'm not here to speak for them, other than to represent their interests, which have been which coincide by and large with the Lidl interest, because
yes, they were set out in the objection themselves about Baines' interest. So they are issues that you have raised in the objection themselves.
So just to summarise what Lidl are saying, it is that there are substantive issues there, and it's not just relating to compensation.
That would be my understanding of it too, having read the objections. Thank you for just clarifying your thoughts, though. So plot 2, Mr. Series, on behalf of the Dunfermlines, are you in agreement that that objection relates purely to compensation matters?
Having just stepped in today to take this, I'm unable to confirm that today. However, could you, on our timescale where I can speak to the client, speak to Meryl and come back to you to confirm?
Yes, I confirm with that when we get on to the next stage, but that's helpful. Again, it's helpful that you could confirm, but just not today.
Yeah, I'll need to take instruction is probably the sum of that point. Okay.
Okay, no, that's fine. And Mr. Ferreira, on behalf of Leo's Garage, are your issues all about compensation?
Most likely, yes.
Okay, thank you. That's helpful to know. Thank you. Okay, plot 3. Mr. Stringer.
Yeah, no, I mean, I think, yeah, I agree with that. I mean, we seem to be slightly mixed. I mean, I think sort of following up from that, but I would like to think whether it's mixed, it probably is mainly compensation. I would like to think that anything will hopefully be addressed through the mutual negotiation and the agreement, and starting off from the 18th of April. So see if we go there. So insofar as it's not just compensation, I think it'll be wrapped up in a mutual agreement.
Okay, it's helpful. And KJJ Foods Limited, are your interests predominantly or only about compensation?
Yes, it is mostly the compensation. Yeah, because we invested quite a lot in the property and everything, so wasn't ready for what's gonna happen.
Yeah, which again you've set out fully in your objection, but I agree. I think it's compensation matters. But again, it's just helpful to know that. Okay. So based on that, I think any inquiry process could involve, subject to what parties want to do, Lidl, in relation to that objection. My feeling is the Verner's objection is purely compensation, but I'll allow you time to come back and confirm that. And if that was the case, they wouldn't take part in the inquiry process. And the Delicatos, I do think, other than the procedural points, which wouldn't really need to be dealt with in an inquiry session, the matters are related to compensation. So that would leave inquiry sessions really just for Lidl, subject to the Divernos just confirming that point. But I'll explain about participation inquiry just for Mr. Stringer's perspective, on the basis she felt there might be a couple of points that would fall out with compensation. So let me just explain what the further procedure would entail for those who could take part in further procedure. So if you object to the compulsory purchase order and your objection is relevant and it doesn't just accelerate compensation issues, you are entitled to be heard at an inquiry session. But if the parties in agreement with the council and the objector are in agreement, I can hold a hearing session, or we can deal with the matter by written submissions. So for those who've not been involved in this process, just let me explain what each entails. So at an inquiry session, which is the most formal process that we undertake, each party is invited to present evidence, and you do that in turn, and you're subject to cross-examination by the opposing party. So the council would present its evidence through its witnesses, and then the objector would have the opportunity to cross-examine those witnesses. The council then re-examines, I get to ask questions, and then we repeat the whole process where the objector presents its evidence through its witnesses. Those witnesses can be cross-examined. Then there's a re-examination, and I could ask questions too, and then that process. So usually parties at an inquiry process are legally represented, and lawyers do the cross-examination, but it's not essential to have a lawyer. You can do your own cross-examination, that's absolutely fine. As I said, inquiry sessions are more formal, and it's more more adversarial than other processes. So the next layer below that is the hearing sessions, and that is a structured discussion between the parties, and I lead that as the reporter. So there's no formal reading of evidence, there's no cross-examination. I prepare an agenda, and when I do agenda, I usually do specific questions or highlight discussion points, and that is normally circulated at least a week, if not 2 weeks, before the hearing session itself, to give parties a chance to prepare to come along to the hearing. The discussion focuses on the matter set out in the agenda. Parties can ask other questions, and there can be follow-up conducted through me at the hearing session. There is no need for legal representation, but lawyers can take part in the discussion. There's no problem with that at all. It's just not such a legal format as an inquiry process. So they are more informal, and it is just basically a chaired roundtable discussion based on questions that I've posed to get information that I need to make recommendations to ministers. So that's the hearing session. And for both those processes, there are disclosures need to take place between now and any of those oral processes happening, which I'll come on to in a minute. And then there's also the opportunity to do written submissions, and I would invite parties to expand or clarify the evidence in writing. You get a period to respond, and then the other party would get an opportunity to comment on those submissions. So the counsel and objector would both submit in writing to me either response to specific questions or expansion of their evidence. Then the counsel would comment on the objector's submission, and the objectors would comment on the counsel's submission. So that's the written submissions part of the process. So that's the three options available to me, subject to parties agreeing if they don't want to do an inquiry session. So if you keep that in mind. So if I can ask those who may be entitled to take part in the inquiry process, let's call it that, what their preference would be and how they'd want to take this forward. So can I go to Mr. Mill on behalf of Little, please?
Yes, thank you, reporter. It strikes me, although I would prefer to take instructions on this, that the less formal procedure would be more appropriate. I think that to have full inquiry with cross-examination set would probably be slightly excessive, given the relatively small scope of the issues. But I'd prefer to take instructions on that. And I don't know whether your intention would be to continue this pre-inquiry meeting, or at least have another one in 4 or 5 weeks' time. If so, then I'd be happy to give an indication of the client's final position by then. That would also have the advantage of allowing the council and Lidl and the galleries to speak further about the servitude and try and get things sorted in that informal way.
You're on mute, reporter.
Sorry. My preference would be less formal. So I would probably earn towards the hearing session. I'll get the council views in a minute. On that point about taking instructions and coming back, I could take the view that, and this would be subject to the council having viewing this, that we what's called assist the process, the inquiry process, given that their discussions are ongoing, and do that for a period of time, and then reconvene in a second pre-inquiry meeting, which would allow, hopefully, agreement to be reached or more progress to be made, and at that point agree the process going forward. But which would kind of be along the lines that you're suggesting there, that maybe 4 or 5 weeks' time we reconvene and see where matters are. Can I just get the council's view on this, please?
Hand over to you, Rod.
I think that would make sense. Yes, I mean, given that the it's really only in relation to plot 1 now that the inquiry will be in relation to, I think probably assisting it for a few weeks to see whether we can reach agreement would make sense. And certainly we agree with a less formal procedure going forward, whether that's by hearing or by written submissions.
And that would also give chance for Mr. Series to come back and confirm plot 2's intentions, and if they agree that their objection is purely compensation, and it would allow, I suppose, plot 3 and 5 negotiations progress too. I suppose from the council's perspective, how long would you want the process to be assisted?
I think I'll pass over to Sat or Graham for that one.
I think obviously because we're trying to progress as quickly as possible, reporter, not to keep passing the buck on, so maybe to Mr. Milne as well, because we're not cited on the conversations they're having with galleries, Lidl and galleries, because effectively we've made the introductions and then we've said to them, it's probably best to try and go away and agree that servitude. So I think Mr. Milne was saying 4 to 5 weeks. That probably sounds reasonable to me. I suppose my question is, will there be some progress made in the interim, I think, between the galleries and Lidl to get to a more secure position, I think, on whether a servitude would be possible? I suppose that would be my question.
Sometimes just having a date encourages people to reach agreement because of the date looming that something has to happen. I wouldn't want to probably do it for any more than maybe 6 weeks, to encourage parties to keep going with negotiations. And at that point, I would be quite keen just at that stage to set dates for a hearing, and the disclosures that took place between then and the hearing. So if parties were happy with six weeks at this point, and we would reconvene at that point, for those who want to take part in the inquiry process going forward. At that point, we agree the next steps. Mr. Milne, would that sound okay from your perspective?
Very sensible to me. Yes, thank you.
Sorry, I mean, Porter, can I just,
Yes.
I support that and just set a timescale. As I say, we've got, and I know we might not be involved in this as we try and sort things out, but we've got this meeting with the council on the 18th. So, I mean, just when you say 6 weeks, I mean, just we're all part of the process. I mean, could you set it to that and just say give to the end of May? Let's be realistic. What's happened here before and things like that. So if you even just did it at the end of May, that's all I would. Other people could live with that.
I've no objection to that. I just don't want it to be open-ended, obviously, because I've got a process to get through. But the end of May, and I can get the case officer to check availability for a second inquiry meeting for, let's say, first week in June.
That's fine with Lidl. Thank you.
And again, we'll just do that virtually. It saves people travelling or trying to get to the same place when there's no need to do that. So we'll do that first week of June, and I'll get the case officer to put a date and a time round, make sure everyone is available. Is everyone happy with that for those who want to take part in the process going forward?
I think I'd be content with that, Porter. Thanks.
Okay. I mean, maybe you'll be able to confirm before that if your clients are happy that their objection is purely compensation and they fall out with this process. And I would encourage the council that even for those objections that are purely related to compensation, it would be useful if negotiations with those parties also continued, albeit they fall out with my process, which I'm sure you will do anyway. So based on that, we would effectively assist the case until the end of May. We'll set another pre-inquiry meeting for the first week in June, and parties can reconvene at that point. I probably would not be minded to assist it again at that point. I probably want to continue with the process. Otherwise, it just becomes open-ended, and that's not helpful to anyone, particularly when you've got timescales for developing and things like that. That would also allow an update on the planning application, perhaps be given at the next pre-inquiry meeting too. That ties in with the thoughts that might be submitted end of May, beginning of June. So I will hold off asking for any written submissions at this point too, and we can cover that at the next pre-inquiry meeting. Other parts of the agenda all related to the next steps if we were going to a hearing or inquiry, and that was the date and duration, the prior disclosure of cases, timescales, things like that. So there's no point covering that now, but we will cover that at the next meeting. So just give parties an insight as to what is required for a hearing, on the basis that I agree that I think a hearing would be more appropriate than an inquiry. When you go to a hearing, the parties taking part in the hearings, for example, council and Lidl, would require to produce a hearing statement, and that would fully set out the details of the case. You need to list in that hearing statement any documents you're referring to, and you list those parties who are taking part, what they're going to address at the hearing, and the relevant qualifications. And I would give you a date by which that had to be done. On the back of that, I would then produce the agendas. As I say, I like to give parties normally at least 1, if not 2 weeks, notice of the issues to be discussed at a hearing, just so you can prepare for that. And then you would turn up at the hearing. Again, we would probably do that virtually, unless with a strong preference that it should be in person. It might just take 5 hours, half a day, go through that session. And then on the back of that, I would then go and write and submit the report. So that just gives you a head up of what is required from a hearing perspective. Whilst the case is kind of on hold, I will probably go and do a site inspection. Does anyone think I need to be accompanied on that site inspection? Or are people happy that I can wander? I've got obviously the CPO map with all the plots on it. Are people happy that I can do it unaccompanied? We'll start with the council, and then if anyone's got anything else to want to add. So, Mr. Patel, are you happy that I can do this unaccompanied?
I'll maybe revert to Ros. Ros, what was our decision on this? Were we suggesting accompanied?
I think we thought, yeah, in relation to the Lidl site, it would make sense to be accompanied so that we could just show exactly what the outline, but what the issues were, and point out the topography of the land and where the servitude is to go, if that's okay.
I'm happy to do either accompanied or unaccompanied. I'm happy to do it accompanied. What I will do, I will get the case officer to circulate suggested dates around all parties, and we will get a date agreed between now and before the next pre-inquiry meeting, and we'll get that done. Again, I think it might take, I don't know, an hour. I mean, so it's a fairly contained part of the city. I would just also want to go and just have a look at each of the plots, understand, the tenants' interest, things like that for the plots where they have got an interest. We would agree a meeting point and take it from there. So I'll get dates set out by the case officer, and we get that agreed and put in diaries, but I'm more than happy to do it accompanied. Any comments from any of the objectors on that? Would you want to take part? You are entitled to come along to the site inspection. Again, just I suppose to outline site inspection, I'm not taking evidence at site inspection. It's purely for me to see the site. It makes it easier for me to understand things and objections when you're hearing more evidence and the issues involved. So it's more like a walkabout. I don't have a massive discussion with anyone, so don't take that as me being rude to anyone. It's just to kind of set your expectations. I'm not there to kind of chat through the evidence in the case. I am really there just to kind of look around the site. I will take notes, I take photographs, and if I may ask for points of clarification, for example, but I'm not there to get into a discussion. But anyone is entitled to attend. But just so no one's disappointed, to manage expectations. I'm not there to have a big chat about the case, but anyone can take part.
I would like to participate as well, if possible, just to filter some extra information, just to get to know each other. Would be great.
Yeah, no, that's absolutely fine. You'll all be included when we're setting the date and the time, so that's absolutely fine. And yeah, you would show me your property, and that would be kind of things I would need to look at. I wouldn't get into a discussion about your objection per se, but of course you're entitled to come along. I'll get dates and a time out for that. Any other questions on the site inspection? Okay, so the date would probably be maybe early May for that, but we'll be in touch on that one. I suppose some maybe just last few preliminary matters. Everything that you need to find on this case can be found on our website, and hopefully you've all had access to that. I will add a link to that to the note of the meeting, just so you can find it. But everything that's ever published on the case, correspondence and things like that, are all published on the website. if you've got any queries at any time, please direct those in the first instance to the case officer who's been issuing correspondence to you, and that's Jane Anderson. Those who haven't been involved in the process, you don't have direct contact to me because I am impartial, and so I can't be seen to be discussing the case with one party and not with someone else. All correspondence goes to the case officer, and then all responses, when she discusses it with me, will come out from the case officer. But that's why you don't have direct access to me. But I do see things that, I mean, obviously, and it's my case, it's my recommendations to ministers. So no one can contact me on the site inspection. I will be with all of you all the time, so I can't go off and speak to one party at any point. And it's just in the interest of fairness and transparency that people understand what I'm doing, what I'm saying, and I'm not kind of perceived to be favouring one side or the other. That's the reason for it. It's just the transparency and the fairness to all parties in the process. But please contact Jane if you've got any queries or any comments, or just need a bit of guidance. She will help. And I will put her contacts in the notice of the meeting to her email address and a phone number for her if you need to contact her. And as I mentioned, I will issue a note of today's meeting, which will be relatively short, but we'll have these key links in it for you, so you can look at the documents I referred to, you have the contact details and a link to our website. So hopefully that's helped today. I know it can be a daunting process for those who have not been involved in it before, and hopefully progress can be made on the objections over the next few weeks. Are there any other matters any party wants to raise at all? If you want to come in, because I can't see all the faces, so I can't ask you to wave your hand or anything like that. But if anyone wants to come in with any queries, then please do that now.
Not from me, thank you.
Thank you.
Okay, great. So we'll come out with those dates, as I say, for the pre-inquiry meeting and the site inspection, and you'll get a note of the meeting over the next couple of days. So that brings this meeting to an end. Thank you all for your participation and assistance. And we will be in touch, and we'll see you again probably at the start of, well, in May for the site inspection and the start of June for the next meeting. Okay, thank you. You're all free to leave.
Thank you. Thank you
Thank you very much.
Thank you.
Bye.
Thanks.